Welcome to my channel. This is the syllabus of Guwahati University. Ekhon Guwahati University Professional Ethics and Professional Accounting System or syllabus. Yar pora moi eta video banaisilu regarding Unit 1, 1.3 need for a professional accounting system aru Unit 3.12 Bar Council rules under Section 49 1C of the Advocates Act 1961. Etuta video bunua hoise already YouTube comment section talot ase. So apart from this, today I'm going to deal with the Contempt of Court Act 1971. Contempt of Court Act 1971 junto Unit 2 dase. Aru Unit 2 okol etu legislation ase belag ekone contempt of law and practice or prescribed legislation hol Contempt of Court Act 1971. So let's begin. Hol past year question papers. Yada say first question to hol define contempt of court with reference to the exceptions to it. So basically first of all contempt of court or definition to provide kora hoise into section 2B and C dia ase. Contempt hol duta type or civil and or criminal. Then with reference to exceptions to it, or exceptions ki ase mane exception mane in another words defenses. Is contempt a civil or criminal offense? Contempt is civil offense na criminal offense. Your simplistic answer hol it is civil or criminal both. Duitar different definitions dia ase. Act on under the what are the different situations where a person can be charged with contempt of court? Kiki situation persons in contempt of court under charge hobo hetu ami pohim. Then comes our other question. Explain the nature and extent of the power of High Court to punish contempt of its subordinate courts. High Court or ki power ase tar subordinate courts rok punish koribole karone subordinate courts man inferior courts under Section 10 of the Contempt of Courts Act 1971. So basically it is Section 10 or kotha koise Section 10 or jikini provisions ase hekini likhibo lagibo. Then can a person be held guilty of contempt of court for criticizing the personal behavior of a judge? As one person guilty hopone contempt of court or jodi to judgeor personal behavior to criticize kore hekini ami pam legislation junat. After reading the legislation we will understand these points. Yar pisot aru eta yearot aru duta question disil. Discuss the meaning, nature and remaining features of Contempt of Courts Act. Meaning, nature of aru features ote same likhibo lagibo jikhini civil contempt, criminal contempt, tapisot defenses, tapisot company company liabilities ki ase hekini likhibo lagibo same kotha features ekei bostu. Then what are the essential ingredients of criminal contempt? Criminal contempt or essential ingredients ki discuss fully. So as regards to criminal contempt ekinit content to bahabo lagibo 10 marks or koribo lagibo. So then aru 1 marks or question bitot hudisil in the year 2016. Okay, Contempt of Court was enacted and passed in the year, of course, 1971. Our Contempt of Courts brought question ahe. For example, etu year to provide kore what is contempt of court, because etu Unit 3, so of course 15 but 10 marks, right? 10 marks all 10 marks ata hole question ahiboi. Discuss the different kinds of contempt in detail. Whether the disobedience of order of munshif amount to contempt. Okay. Tapsot 2 marks or eta question ahisil. 2C, power of review under the Contempt of Courts Act 1971. Review ki power ase review korar. Then aru the year 2015 ahisil. Whether there is clear and definite definition of the expression contempt of court under the Contempt of Courts Act 1971. Yes, as a definition under Section 2B and C. So let's begin. Contempt of Court. Object of the Act. Contempt of Courts Act 1971 or underot ase hekon act. Object. The main object of the Contempt of Court Act is to protect the dignity and decorum of the court. Court or dignity to protect kora mainly, and decorum, dignity and decorum of the court, and to uphold the majesty of the law. Laws into the majesty ase power ase to uphold kora. The object is not to protect the judges from criticism. Your object to then comes the object is not to protect the judges from criticism. Just hokolok criticism or protect kora object nahoy. By providing punishment for contempt of the court, the ability to deliver fearless and impartial justice is strengthened. Criticism is an important thing. Fair criticism, contempt nahoy. But fact is that judges are fearlessly and impartially justice provide kore, deliver kore. His system to straighten kora hai main object. Jate punishment hiatok provide kore june order any kind of directions follow no kore. Ba court reputation lower kore. Ba administration of justice interfere kore. Tenukam punishment provide kora jai. Then comes definitions. The definitions given in the Act for the term contempt of court is not exhaustive. Definition to exhaustive, not first thing. It is difficult to define it by words because the scope of the contempt of court is very wide. Contempt of court or scope to very wide. Contempt means, first of all, it will have general meaning. any disrespect to the authority of law. Law into authority. He authority to prati kora jikunu dhৰণৰ disrespect. Disrespect word to first word use as any disrespect towards the authority of law. Then comes disobedience. Disobedience means obi nakora. That means follow nakora of the orders of the court. Court or order follow nakora. This is the general meaning. Then third, disturbance to the proceedings of the court. Court or into proceeding. He proceeding to interfere kora, obstruct kora, but disturb kora. So tinta word, first of all, disrespect to the authority of law, disobedience of the order of the court, disturbance to the proceedings of the court. Eto hol general meaning of contempt. Yar pisot contempt or duta bhag ase. So section 2A of the Contempt of Courts Act 1971 provide korise je contempt includes civil contempt as well as criminal contempt. Then civil contempt or definition provide kora hoise section 2B or criminal contempt or definition provide kora hoise section 2C. First of all, ami criminal contempt porhim. Section 2B defines the term civil contempt. First of all, ami civil contempt porhim. It means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court. Number 1 and number 2. Yet duta point ase. Point number 1 ase willful disobedience. Disobedience means obi nakora, follow nakora. Okay, that's why it is disobedience. What kind of disobedience it is? Willful mane jani nijor issa anuhori. Willful disobedience. Jane je teo disobey kori ase he order to. Willful disobedience to any judgment, decree, directions, or order or writ. Eto hobo pare any kind of judgment ba court pass kora kiba decree ba court provide kora kiba direction ba order ba writ jurisdiction under article 32 and 226 or other process of a court or jikono court or process of a present to willfully disobey korile. Eto hol civil or pare, not criminal. Then comes 2 willful breach of an undertaking given to a court. Jodi court kiba undertaking there that willfully had to breach kora mane breach kora mane tak fulfill nakora of an undertaking given to a court. For taking action for civil contempt on the ground of willful disobedience of the court order, it should be established that the court which has passed the order has jurisdiction to pass the order. Kiba the action lobolo hole on civil contempt, action lobolo hole first of all eto hobo lagibo willful disobedience or ground kiba jodi civil action loa jay contempt or garne, then first of all eto prove koribo lage je court or he jurisdiction asil he order to pass korar. Eto eta important precondition. Court or jurisdiction asil je order to pass korar by direction by anything. Jurisdiction to important point. Then comes a disobedience of an order passed without jurisdiction is not a contempt. Must prove that the court has no jurisdiction. Kiba ta court or order kunobai disobey korile the order juntu pass korat court or kuno jurisdiction nai, that means court or kuno authority nai, any kind of authority nai, then hetu contempt na hoy. Then comes a willful breach of an unconditional undertaking given orally or in writing under a person, either in person or through his advocate, will be treated as a civil contempt. Willful breach kora ki hol unconditional undertaking. Kiba ta undertaking dise either orally or in writing, either in person or dora by advocate or dora, hetu eta contempt, civil contempt hobo. But whether undertakings are given orally, the court shall record it in the proceedings. Jodi orally undertaking to dia jay ni tehale court hetu record koribo proceeding. Then breach of a compromise entered in the court cannot be treated as a contempt, civil contempt. Or that has a breach of a compromise. Kiba ta jodi compromise court or throat enter kora hoy between two parties or he compromise to follow kora hoy ta breach kora hoy ta conditions follow kora na hoy, tetehale hetu civil contempt no pore. The remedy for in such a case is only civil suit for specific performance of the promise. Tagane remedy hobo civil suit file koribo pare on what grounds? For specific performance of the promise. Promise to perform jede kora tagane civil suit civil suit such a case only file a civil suit, but hetu contempt of courts na hoy. Then comes punishment. Then important section is section 12. Section 12 punishment provide korise. Prescribes the punishment for contempt. Court may award any one of the following punishment. Talot thaka jikono eta punishment court award koribo. Then comes first of all imprisonment. But it is only simple imprisonment. That means rigorous imprisonment with hard labor na hoy. Simple imprisonment for a term which may extend to 6 months. So SCM. Simple imprisonment for a term which may extend to 6 months. Then comes fine which may extend to rupees 2,000. Only 2,000 rupees fine. 3 both. The punishment I imprisonment and fine together. Both the punishment, duita punishment. Eto hobo pare imprisonment for a term of 6 months, simple imprisonment, but fine of rupees 2000. Duitai provide koribo pare. Then comes criminal contempt, section 2, clause C. It is small c hobo, defines the term criminal contempt. Which means number 1, publication of any matter by word spoken or written or by sign or by visible representation or otherwise. Kiba eta matter first of all publish koribo lagibo. Eto any medium, any format publish hobo pare by words, শব্দৰ দ্বাৰা, শব্দটো লিখাত হ'ব পাৰে, spoken, written or spoken বা spoken words, spoken or written or by sign kiba sign provide kori or by visible representation or otherwise. Then 2, doing of any other act which ba publication ba beleg act kora juntoe. Point A, scandalizes or tend to scandalize or lowers or tend to lower the authority of any court. First of all, scandalize kore, but tend to scandalize means jute da scandalize kora tendency ase. Or lowers or tend to lower kora ba lower kora komor eta tendency ase, the authority of any court or kiba the authority. Then 2, prejudices or interferes or tend to interfere with the due course of judicial proceedings. Prejudice kore ba interfere kore. Prejudice kore mean prejudice or interferes or but tendency ase junto interfere kore ba prejudice kore due course of any judicial proceedings or logot jodi proceedings jodi kiba interference ane ba prejudice ane. This is second ground. Then third hole, interferes or tend to interfere with or obstructs or tend to obstruct, interfere kore. Yeto interfere how to use ase বা obstruct, interfere কৰা এটা tendency থাকে, হেতুতে হল tends to interfere with or obstructs মানে বাধা দিয়া or tends to obstructs বা বাধা দিয়া কিবা এটা tendency থাকে, the administration of justice to administer কৰাত যদি কিবা বাধা দিয়ে. So ইয়াত word we use আছে scandalizes, tend to সবতে use আছে or tend to scandalize বা lowers. এটা শব্দ use আছে what authority of any court. Second is a prejudice or interferes, word duta use ase with what due course of any judicial proceeding. Third dut interferes or obstructs duta word keyword use ase with administration of justice. Yat kisman keyword use kini manat rakhile answer to likhibo pari, definition to likhibo pari. Then comes the meaning of the term publication. Junto publication me definition at paisu. Publication means publishing something orally or in writing. Kiba ta publish kora already শব্দৰ দ্বাৰা বা লিখাৰ দ্বাৰা writing through newspaper, pamphlets, radio, television, cinema. Newspaperত হলে বা pamphletত হলে কি হ'ব, এটো writing হ'ব. Radio, television বা cinemaত হলে এটো orally হ'ব. Conversation orally between two persons cannot be treated as publication, but conversation between two persons publication নহয়. কিন্তু publication হ'বলৈ হলে, for example A and B কিবা এটা conversation কথা পাতি আছে regarding something, this is not publication, but third party to another person থাকিব লাগিব যাক publish কৰিব সেই statement to. As law of defamation almost similar. Then another point, to decide criminal contempt, the absence of criminal intention on the part of the person who has published a matter containing criminal contempt or done the act of contempt will not be taken into consideration. To decide criminal contempt, decide kora samoyt the absence of criminal intentions on the part of the person. Jodi manhujonor kiba eta criminal intention nai, kintu ami criminal law janu je malafit intention, guilty mind eta thakibo lagibo. যদি guilty mind নাথাকে তেতিয়াহলে হে personজন criminal liability পৰা exempt হৈ যায় under as regards to IPC পাইছিলো section 76 to section 106 of Indian Penal Code de কিছুমান provide কৰিছিল something like defenses. So intention is an important thing যিকোনো ক্রাইমৰ কাৰণে, কিন্তু civilত intentionটো important নহয়. But ইয়াত কৈছে যে to decide criminal contempt, the absence of criminal intention on the part of the person who has published a matter containing criminal contempt or done the act of contempt will not be taken into account. A intention থকা বা নথকা to immaterial. Eto eta exception menstruate exception থকা বা নথকা to it's immaterial. That means it will not be taken into consideration or account. Then cases ase just like in EMS Nambo 3 Bath versus TN Mambier AIR 1970 SC 2015. 2015 means this is a recent case oh no SC but 1970 sir case SC 2015. Okay, AIR 1970 SC 2015 case to hall EMS Nambot rebat. Okay, Nambot rebat. Nambot rebat. TN Mumbai or TN like something like Tamil Nadu and Mumbai. Okay, so you have to remember it. The case, very important. AR 1970 SC 2015. Okay, the then Chief Minister of Kerala. Tamane to case to Kerala case second man namkini difficult mood. Then that then Chief Minister of Kerala, CM of Kerala, Mr. Nambotri Bhat, in a press meet expressed the following about judiciary. Judiciary is responsible for the suppression of people. Teo question je judiciary kotha. Judiciary responsible hoy manhok suppress korat. Mane suppress kore mane damon korat. Judges are favoring some class of people and working against other classes. Judge কিছুমান class of মানুহক favor কৰে আৰু কিছুমান class of মানুহৰ against কাম কৰে. That means judicially biased. Judiciary is acting against the interest of working class and the agriculturalists. Judicially working classes মানে কাম কৰা যিখিনি labor মানুহ হেখিনি বা agriculturalists যোনখিনি খেতি কৰা মানুহ হিহতৰ interestor against কাম কৰে. Judiciary is helping the oppressor group. Judiciary oppressor group to help korise. Juntu group oppress kore. He group to help korise. The Supreme Court held that the act of Mr. Nambotri Bhat amounts to criminal contempt. The Supreme Court kosil je Mr. Nambotri Bhat junkhini kotha koisil. Press or honmokhot because press is the third party. They publish koisil through the press, through orally spoken words dara kiba ta publish koisil. Publication means making known it to others, right? So it was a criminal contempt amount korise. Making complaint against a judge about his misconduct with sufficient evidence to the higher authorities, it is not a contempt, but aru eta kotha ase jodi kiba ta complaint feel kore judge or against tar misconduct kiba ta jodi thake ta misconduct kore with sufficient evidence aru he complaint to accompany koribo lagibo sufficient evidence logot complaint plus sufficient evidence jodi feel kore higher authorities of judge or against ground to ki hol ta misconduct korise kiba ta. It's not a contempt, it is a contempt nahoy. Can you same complaint jodi belag manor publish kora hoy teta hoy to contempt hoba. That means simply to press ok koise press eta authority nahoy, proper authority nahoy. For example, there's a higher authority source judge behe kiba ta complaint diye with sufficient evidence. To sufficient evidence say that means he is armed with sufficient evidence. Teta hoy to contempt nahoy because obviously the lawful manner kiba ta korise to take some proper action. Their right is enake korar. But in this case, etu press of quato contempt hoise. But the same complaint is published in any other manner. So the same complaint belag manner published kora teta hole to contempt hobo. Then comes preventing the court from executing the court order, threatening an advocate not to appear in a particular case, threatening the witness, preventing the witness from attending the courts, preventing the commissioners from performing his duties are treated as criminal contempt. Now here the case is DC Saxena versus CJI, Chief Justice of India. Etu case ala besi bhalko buji pa jabo, but that ki koise preventing the court from executing the court order. Jodi court or karoba court or order to execute korat kunubai prevent kore, threatening the advocate ok threaten kore dhamki diye not to appear in a particular case to appear hobo no bole advocate ok threaten kore, threatening the witness jodi witness ok threaten kore, preventing the witness from attending the court or jodi witness ok prevent kore court attend koribo noribo, preventing the commissioner from performing his duties as treated as criminal contempt. Jodi commissioner prevent kore the duty perform kora thekini hol criminal contempt, but thekini civil contempt nahoy. Then comes defenses in civil contempt. Civil contempt out ki defenses ase. Defenses. So by exceptions, but civil contempt not punishable. Kuntu granted civil contempt punishable nahoy. So number 1, disobedience of the order is not willful. Disobedience of the order is not willful. First thing hol disobedience mane follow nokora order to obi nokora jun order korte pass kore hetu jodi willful nahoy mane ter issanu nahoy. If the disobedience of the order is accidental hisabe teo nojana koise teo expect koribo bisara nasil teo intention nasil hetu kora, or which is not willful, then it is a good defense in civil contempt proceeding. Teta hole etu good defense. Accidental ba hoy ba willful na hoy jetia. Then comes to order passed without jurisdiction. It is already mentioned kora hoise court kiba ta order pass korise, but court ei order to pass kora kono jurisdiction nai. Jeni khore pura jurisdiction na hok lagile mandatory jurisdiction or any kind of jurisdiction, territorial jurisdiction hobo pare. Teta hole he order to void hoy. Teta hole eta void order obi kora ekei kotha, because order to in existence nahoy, order to exist na kore. Then comes point 3. Order disobeyed is vague and ambiguous. Order to jonto disobey kora hoise etu vague mane clear নহয়, specific নহয় বা complete নহয় বা বুজাত difficulty আহে বা ambiguous মানে puzzling মানে confusing. An order is treated as vague if it is not clear, specific or complete. যদি হেতু clear নহয়, specific নহয়, complete নহয়, for violation of such order contempt proceeding cannot be taken. তেনেকুৱা order violate হলে contempt proceeding কৰিব নোৱাৰি. Then 4. Order involves more than one reasonable interpretation. Interpretation of statutes order bilako interpret korbo pari, right? If the order of the court involves more than one reasonable interpretation, court eta order provide korise kintu he order etatko duta interpretation ulaba pare mane duta possibilities thake. Titia no, the one interpretation is adopted by the party. Tare bhitor eta interpretation party adopt korile. So and acted in accordance or accordingly act korile which is interpretation, then he cannot be held liable for contempt of the court for not following the other interpretation to follow nokora kane liable na hobo. Keteba eta hobdore belag interpretation thake. Similarly court or order or duta tinta interpretation thakibo pare, tar eta interpretation pick kori follow korile because unto interpretation follow kora manujoner kane lagise je court etoi mean korise really, so that contempt na hoy. Then point 5. Compliance with the order is impossible. Order to comply kora possible nahoy. Impossibility means that the implementation of the order is practically not possible. Mane order to implement kora ba execute kora to practically, from the practical point of view, possible nahoy. Impossible is different from mere difficulty, or impossible word to difficult word to koi different. Mere difficulty is not a defense. Mere difficulty kosto hoise kiba ta kam kora eta ta defense nahoy, কিন্তু impossible something which cannot be done. The person charged with contempt must prove that the impossibility of compliance with the order. Here the example is impossible order by case eta ase. Etu hol Amar Singh versus KP Githa Krishnam. Amar Singh versus KP Githa Krishnam. Case to hoise ki the court has passed on order to give some benefit to the retired employer. Court eta order pass kori pelai retired employer so kisuman benefit dise retired mane sun retire hol. This order was not implemented. Order to implement kora nasil. In the contempt proceeding, it was argued that contempt proceeding to argue kora hoisil the implementation to a huge expenditure involved kore. Bahut taka kharas koribagia hoba implement koribole jonto practical at that point of time possible nasil. So that's why defense to accept kora gol. The defense was not accepted because this is something difficult but not impossible. Then comes point 6. No knowledge of the order to kunu dhornor knowledge nasil. A person cannot be held liable for civil contempt if he has no knowledge about the order. Civil contempt or karone ejon person liable nahobo jodi tar ko knowledge na thake order to be. If he has knowledge about the order, though it is not officially communicated to him, so do it officially communicated kora hua nai, then he cannot put his defense from violations of the order. So knowledge is an important thing. Etu defense hobo pare or liability so ahibo pare. Contempt of civil contempt eta case ase. Re Vijay Chandra Mishra, Re Binay, not Vijay, Binay Chandra we know Mishra, then Mishra book bilak bahulor. Re Binay Chandra Mishra, AIR 1995 case SC 2348. The Supreme Court held that for contempt of court committed by an advocate, contempt of court jodi advocate ejonor commit kora hoy, he shall be suspended from practice for a fixed period or he shall be permanently restrained from practice. Top practice or suspend hobo pare eta fixed period or karone ba permanently to restraint hobo pare practice korar pora Supreme Court held korisil. The Supreme Court Bar Association filed a review petitions. Tetia Supreme Court hedo decision dile. Afterwards this SC Bar Association ne review petition eta file korile. Supreme Court order against a review petition file koribo pari against this order, in which the Supreme Court held that for contempt of court, the court cannot cancel the advocate's right to practice. Contempt of court or karone court in which that Supreme Court ako college for contempt of court, the court cannot cancel the advocate's right to practice. Contempt of court karone court advocates or right junto ase court practice kora he right to cancel koribo nware, but he shall be suspended from practice for a fixed period. But suspend hobo pare, and suspension and cancellation both are different thing. Suspend means for a temporary period of time, but kiba ta specific fixed period karone hobo pare. For the civil contempt, normally fine alone will be imposed. Civil contempt karone punishment to ki ketiba fine alone, that means okol fine hobo pare, for example 2000 rupees. If the court thinks that fine alone is not sufficient punishment, then jodi court bhabe fine alone sufficient nahoy, tetahle punishment provide korok. punishment imprisonment simple imprisonment for 6 months it on punishment then he shall be put in civil prison instead of ordinary imprisonment তাৰপিছত আছে if the contempt of court is committed by company in collusion with the directors company to commit কৰিলে contempt of court তাৰ লগতে directors secretary বা managerial staff এও commit কৰিলে because company এটা separate legal entity so company commit কৰিলে company liable হ'ব আৰু তাৰ লগতে যিখিনি officers আছে সেইখিনি যদি হিয়তৰ consent connivance দৰা বা knowledge দৰা হয় তেতিয়াহলে হিয়তৰ liabilities আহে so directors secretary and managerial staff then shall be detained in the civil prison other than shall be then হিয়তো civil prison detained হ'ব then if the contempt is committed by firm যদি এটা firm এ contempt commit কৰে then the punishment shall be enforced against the partners of the firm punishment partners of the firm against the enforced হ'ব তাৰ কাৰণটো হ'ল কি because firm এটা separate legal entity নহয় সেইকাৰণে partners for unlimited liability আছে so partners themselves liable হ'ব but company is a different thing it is a separate legal entity company এটা limited liabilities আছে আৰু যোন কিজন director secretary বা manager responsible হে contempt process act ৰ কাৰণে হে manager কিজনে responsible হ'ব বা punish shall be liable to be punished then defenses for criminal contempt section 3 to 7 deals with the defenses available in criminal contempt there as follows a section to another khandor section 3 and 7a or punishment provide কৰিছে section 12a or definition section 2b civil contempt section 2c criminal contempt yeah whole defenses for criminal contempt so section 3 provide কৰিছে innocent publication a person shall not be guilty of contempt of court if he had made any innocent publication it isn't person guilty নহব for the contempt of court যদি তো innocently কিবা এটা publish কৰিছে innocent means to willful নহয় of any matter pending before a court into matter court pending is already and without knowing that the matter is pending in the court or it knowledge na is a matter to court pending hoise ta nazane je matter to court pending hoise a person charged with contempt must prove that the publication is made without knowledge that the matter is pending in the court so eta boste proof korba lagibo innocent publication er karone je matter to je court pending hoise he person jona knowledge nai nazane he is not aware of it then comes publication relating to a decided cases so the decided case or related kiba publish kore for example section 3 clause 2 so not clause subsection 2 publication about the decided case is not a contempt since the case is already decided by the court case to already decide kora hoi gol the publication is not going to interfere with the disposal of the case publication to a case to disposal kora ba judicial processing to interfere na kore ami paisilo I think point 2 paisilo interfere korile contempt hoy criminal contempt hoy so that's why it is not treated as contempt because it already decided but in this case innocent publication yat publication to the pending hoise person jone najane maybe the paper decided already hoy gol so he has right to publish or something else then section 3 subsection 3 provide korise distribution of publication without knowing that it contains contempt of court matter kiba ta distribute kora distribution of publication without knowing that it contains contempt of court matter to nazane je eto contempt of court tor kiba ta matter hoy if a person distributes and publishes without knowing that kiba ta distribute korile publish korile distribute korile without knowing nazana koi that it contains contempt of court eto contempt of courts contain kore matter when it cannot be treated as contempt if the publication does not contain the name and address of the author jodi publication to the second time name or address author contain nokore the publisher and the printer then this defense cannot be used by the person distributing such publication because basically jodi person jodi nazane je to contempt matter hoy dita hole publish korile then tao liable na hoy but kunubai jodi kiba ta publish korile kintu he publication to kune publish korile tar name author name by address dia na thake dita hole composite intentional to jane যেটো contempt হবো হেকানে তাও কনসিল কৰিছে কিবা এটা নিজৰ নামৰ এড্ৰেছ কনসিল কৰিছে তেতিয়া এই ডিফেন্স এভেইলেবল নহয় then comes another point this is section 4 fair and accurate reporting of judicial proceedings fair and accurate reporting of judicial proceeding fair or accurate শব্দটা ইউজ কৰিছে যোনটো fair হয় যোনটো accurate হয় that means correct হয় judicial proceedings or kiba correct report publish কৰিছে this is not because we are following the principles of openness and matter of administration in the matter of administration of justice ami principle of openness follow কৰিছো যেতিয়া justice administered korat in the matter of administration of justice but here are exceptions ase the following reports of judicial proceeding though it is fair and accurate jodio to fair hoy talot likha jikhini proceedings ase reports of judicial proceedings jodio fair accurate hoy tathabi to contemporary treat hobo for example it was exception upor thoka rule tour etu hol exceptions number 1 reporting of the proceedings against any law which is enforced kiba da law কিবা এটা ৰিপৰ্ট proceedings কিবা এটা যোনটো any law which is in force যদি lawটো in force থাকে operate হৈ থাকে means reporting of proceedings when the court has prohibited the reporting in the interest of general public যদি কোৰ্টে নিজে prohibit কৰে সেইটো report কৰিব নালাগে because general public are interest concern কৰি বেলে public interest in the general public তেতিয়াহলে তাৰ পিছত যদি কৰে তেতিয়াহলে সেইটো contempt হ'ব সেইটো fair হোক লাগিলে fair বা accurate হোক তথাপি যদি কোৰ্টে prohibit কৰে কোৰ্টে যদি মানা কৰে publish নালাগে কৰিব কিন্তু general public interest কাৰণে তাৰপিছত publish কৰে then hetu contempt hobo then comes 3 reporting of proceedings conducted in the judge's chamber in the interest of defense of public order then comes reporting of information relating to secret process so kiba information publish korile discovery or invention belak kiba discovery invention ba secret process publish korile which is an issue in the case juntu he case to the issue tetale hetu this will amount to contempt তাৰপিছত order defense আছে section 5 provide কৰিছে fair criticism of judicial acts fair criticism a proper and fair comment on a decision is not a contempt of the court proper fair comment jodi hoy comment to proper hoy and fair hoy criticism is permitted to the extent where it does not interfere with the administration of justice criticize kora korba but fairly he fair criticism to contempt na hoy or and the second thing jodi he criticism to administration of justice interfere na kore justice diaut and justice provide korte interfere na kore then in that case also he hetu contempt na hoy so it is open to anyone to express fair reasonable and legitimate criticism of judicial decisions because we have freedom of speech and expression I mean freedom of speech and expression is article 19(1) a under ami criticize koribo paru the government or judicial acts reports anything but condition ase criticism to fair hobo lagibo fair means on reasonable ground aru contempt proceedings or khetrot criticism to apart from being fair hetu administration of justice ok interfere nakorile then hetu contempt na hoy but jodi administration of justice ok interfere kore justice system to interfere kore titia hole hetu contempt hobo then comes 6 bona fide complaint against a presiding officer of a subordinate court jodi the bona fide means what in good faith jot malafide intention nai complaint jodi kora hoy against whom presiding officer of a subordinate court jodi court or subordinate court man tolor lower court or presiding officer against kiba jodi complaint feel kore complaint to junto bona fide in nature that means fair that means malafide intention nai bona fide head all section 6 a bona fide complaint made in good faith means due care and attention against a presiding officer of a subordinate court or presiding officers or against jodi kore to the higher authority so the higher authority sok subordinate lower authority eta complaint your higher authority to fill kore then who have control over subordinate court it is not a contempt hetu contempt no reason first of all it be bona fide that means in good faith means due care and attention as a malafide intention na hoy second thing hetu complaint a lawful process or dara fill kore proceedings follow kori subordinate officers or kiba ta kam tar superior officer sok complain kore so it is a lawful process law dara hoy so with bona fide intention ba bona fide with due care and attention in good faith so hekane hetu contempt na hoy then comes point 7 no substantial interference with the administration of justice justice to administer kora ko substantial interference na thake hetu the important thing it means an act which is technically a contempt but just like does not substantially interfere with the administration of justice for such act no punishment is awarded jodi eta act junto technically from technical point of view eta contempt hoy really but hetu administration of justice to interfere na kore tetia hole hetu contempt na hobo mane main kotha to hol jodi kiba da ekta administration of justice ok interfere kore lagile fair criticism hok hetu contempt hobo kintu kiba da bostu no technically contempt hoy but administration of justice ok interfere na kore tetia hole hetu against a contempt proceeding anar eku dorkar nai so ami aji just criminal contempt just civil contempt criminal contempt your eta definition section plus defenses and along with it punishment as per section 12 deal korisu along with I think tinta case law apart from this yat aru kisman points ase so jikini question past question hudisil hini second video to deal korim because already the video bahut long ase 34 minutes so thanks for watching. If you like my videos, please do not forget to subscribe.